Everybody, Rich with Prep U down here in the old bunker, right by one of my favorite stores lockers. Hey, real quick, there's going to be a quick video, a couple things. I just want to go over real quick some news that transpired on the PICA law and something on FOID records I want to go over too. So, as the title of this video said, that another challenge has been brought to SCOTUS on PICA. And this was done just recently on Wednesday. Basically, Wednesday, the U.S. Supreme Court docketed a case out of Naperville where plaintiffs challenged the city and state's gun and magazine ban. Plaintiffs are seeking an emergency appeal of the Seventh Circuit Court of Appeals three-judge panel ruling for the state. The court held that plaintiffs failed to demonstrate the act is likely unconstitutional. But as noted, the banned firearms and magazines are in common use for lawful purpose, and the act is clearly unconstitutional under Heller and Bruin. That's what the plaintiffs basically have said. Other areas that they argued that the split three-judge appeal panel got it wrong. They said the majority incorrectly held that banned firearms are not arms, that the common use test is faulty, and that the court misinterpreted recent U.S. Supreme Court precedent. All right, so that's the second one. And on Thursday, Justice Amy Coney Barrett ordered the state to respond to the plaintiff's motion by December 6th. So that's the second one. But just to go back, just to tweak your brain a little bit, the first appeal was brought by Representative Dan Caulkins and his attorney, Jerry Starks. And they raised the question of conflict of interest, if you remember that. Basically, Caulkins motioned for Justice Mary O'Brien and Elizabeth Rochford to recuse themselves because of their campaign for their seats received more than $1 million each from the named defendants, basically Pritzker, and there was also some money from Welsh, the head, I believe he's head of the House. And the state had until December 14th to respond to that motion. Well, lo and behold, two things have happened on the first challenge. One, 2 weeks before it's that the state had to respond, J.B. Pritzker on Friday said, we're not going to challenge it. We're not going to say anything. So don't expect us to, file anything regarding that motion. And Jerry Stocks, Representative Caulkins' attorney, just found out recently that there was, now that was $2.3 million, okay, from Pritzker and Welsh and a few others. But they just found out that there was another $7.3 million in undisclosed indirect support, which is basically ads, articles, and stuff like that. And they didn't know about this till about a week ago. So what they're going to do is they're going to file a supplement to the first appeal. And the problem with this is Mr. Stocks reported was that a lot of this money is coming from the other two branches of government. Okay, that would be from the governor's office and the House of Representatives and the Senate side. That's where the money's coming from, which is kind of, they're supposed to be equal and separate, but it doesn't seem like they are. And then talking about other challenges to this that are still out there, you've got the Illinois gun and magazine ban plaintiffs from various cases are seeking a full panel review from the Seventh Circuit Court of Appeals. That request is still pending so that's the one where they want a full court, not just the three judges, they want full court. Okay, which these cases that I said before, or just talked about before, if they have to recuse themselves, there's no way to have a full one, but we'll see what happens. Then there's a request still pending in the Southern District of Illinois with federal judge Stephen McGlynn is set to hear oral arguments on the 12th on a motion from plaintiffs seeking to enjoin the state from enforcing the January 1st ban registration deadline while the case proceeds through the courts. McGlynn says he hopes to have a ruling on that before the Christmas holidays, which would be a really good idea because I think they go on break and then, hey, it's the first of the year on top of that. If you want to hear something that's a little bit more in depth, and I've told you this all the time, I'm sure some of you are have already seen the video, but it's from Greg Bishop from the Center Square, is talking with Representative Caulkins' attorney, Jerry Stocks. This really pretty much is a must-see video. It does get into a lot of legalese, but they really bring up a lot of things. There's some good comments made from Pritzker regarding this. So I would definitely, when this video is over, don't stop it now, we're not done, go check out that video. It's pretty interesting. So things are getting interesting. And basically Jerry Stocks kind of talks about how he found out about the 7.3 million of undisclosed indirect support and what they're going to do exactly with the supplemental. Okay. In the other case, I talked about this. The Illinois Supreme Court stated FOID records exempt from public disclosure. Well, that's a good thing. Okay, that's a real good thing because you don't want people bringing FOIAs forward and trying to get information on, blanket information, who has a FOID card. So the Illinois Supreme Court ruled Thursday that people may obtain records about their firearm owner identification cards, but they may not use the state's Freedom of Information Act to do that. Well, the thing is that there's many different ways through the Firearm Service Bureau to get information on your FOID. Basically, you need to get an account on there, okay? If they would have allowed this, it would open it up for anybody to be able to do that. So let's see what they said. In a 7-0 ruling, the court said Illinois State Police acted properly when it denied FOIA requests from individuals who sought copies of letters explaining why their FOID card had been denied or revoked. But the court also said those individuals could have obtained records through other means, just like I said. And I've told you that in other videos, that's how you get it. You get it through the Illinois State Police Firearm Service Bureau website. The case revolves around a 2011 amendment to the Freedom of Information Act that exempts from public disclosure the names and information of people who have applied for or received FOID cards or concealed carry permits. And I think this really came out of, if you remember, Attorney General Madigan, when she was the Attorney General of Illinois, tried to get the records from the state police, and the state police said no. You can't have those records. Those are private records. And then also, according to the briefs filed with the court, state lawmakers passed the amendment after the Associated Press filed a blanket FOIA request seeking the names of all FOID card holders in the state, along with their expiration date. So based on those two things, and I'm not really sure when the whole Madigan thing happened, but that was also one of the cases. Basically, the case out of Madison County said that these people couldn't find out the status of their card or the status of why they were revoked or whatever. There's other ways to do it. FOIA was not the way to do it at all. So both the trial court and the appellate court pointed to the use of plural language in the 2011 amendment that prohibits the release of names and information of people who have applied for or received permits. They argued the use of plural words indicate lawmakers did not intend to prevent people from accessing their own information. Again, you can access your own information, you just can't do it through a FOIA. But the Supreme Court rejected the analysis, saying that the use of plural words does not in itself mean that a request for one's own information would be permissible under the 2011 amendment. So the court ruled, noting that the individuals could have obtained their FOID card applications and revocation letters through the Firearms Service Bureau, which is a division of the ISP that process FOID cards. Okay, I want to thank the Capital News for that information. Let me show you right here. Capital News, they're awesome as always. Really good place. The other stuff, basically, there it is. Greg Bishop, Center Square. So thank you. Kudos. I don't want to plagiarize. It was from those guys. So anyhow, the good thing, going back to the FOID card real quick, the good thing about that is other people can't get your information. Only you can get your information through the website, through your personal portal, okay, to the Fire Service Bureau. So I don't know why they tried to use the FOID for you, because there's other ways of doing it. But they held against them, which is good for us. It's a good thing that the lower court's ruling didn't stand, because that means newspapers, courts, and stuff like that could get our records, and they've got no business having those records. So actually, the state has no business having FOID cards, but that's besides the point. At least they can protect our information as long as they've got it. So that is it. Like I said, do go see Greg Bishop's video. It's new. I think it's been out for about 4 hours on YouTube. And thanks a lot. Take care. And if there's any more news regarding PICA, we'll bring it to you.